Okay, therapists, it's time to talk about something that none of us want to deal with, but all of us absolutely have to, which is getting subpoenaed to testify in court. I know this is incredibly stressful because as soon as you get that notification, what do? We start worrying. We start worrying about what we can say, what we can't say, how to protect your client's confidentiality while also staying compliant with the law. And then being requested to testify in court takes up so much time and energy. But here's the one thing to know: you don't have to figure this all out on your own. I've got you covered. Today, I have brought in Rich Harris. He's a family law attorney and the managing partner of Harris Law, based in Colorado. And he knows this world inside and out, and he is here to share actionable advice with you so you can navigate this inevitable situation like a pro. Welcome, Rich.
Well, thank you, Dr. Lisa. It's great to be here and great to talk to your audience.
Thank you. I always love every opportunity to visit with you, Rich. I know we've done a few things together over the years. You've been so gracious to have me at some of the events that you host through your law firm. You put on just educational webinars for people going through different things. And so it's nice to have the opportunity to pay it back a little bit.
Well, likewise, I appreciate that. I know that you and your practice, you really focused on helping your practitioners and especially the folks that you guys offer counseling to. I feel like we're kindred spirits in the service world.
We are on the same mission. Well, and that's honestly like the intention of why I reached out to you to come on to the show today and talk about this situation of therapists getting subpoenaed. I mean, every time it happens in my practice at Growing Self, it's like there's this, I mean, a panic attack. We need to do a lot of like consultation. What do I do? And especially with earlier career clinicians, but even with experienced therapists, everybody's like, oh no, because I think it brings up so much stuff. There's a lot of anxiety it comes into. I feels like I have to do this, right? It feels like if I don't show up and testify, I'm going to get in trouble. But then it turns into, what if I say the wrong thing? What about client confidentiality? And oftentimes this can be like related to a custody dispute situation based on couples counseling. I mean, like there can be all kinds of stuff going on here. And so I'd really love to unpack this so that therapists listening can get your perspective and like do's and don'ts, right? That can help just navigate the situation and make decisions so that they can handle this confidently. And I know there's a lot to talk about here, but let's start with this. I think that a lot of therapists assume that if they get subpoenaed to testify, that means they have to. Is that true?
It's not, and I really appreciate the question. It's not,
Okay.
although it's important, obviously, to take it seriously.
Mm-hmm.
There are things you can do, and I want to talk about some of those practical things
Mm-hmm.
because the reality is that you, as the clinician, certainly have rights. You have obligations to your clients, obviously. And the reality is that lawyers don't always follow the rules, believe it or not.
Mm.
Um, Lawyers practice at times in a haphazard manner.
Oh,
And a lot of times these subpoenas are not proper.
really? Improper subpoenas. What does that mean? Tell me more.
You bet. Kind of setting the stage here, let me give
Hmm.
you my sort of professional bias when it comes to this issue.
Okay.
What I would say is it should be a rare occasion where an ethical attorney actually serves a subpoena on a therapist. Number one, it is rarely directly relevant to the issues before the court. More importantly, there are better ways typically that a lawyer can get the information. And then thirdly, for everybody, and I suspect there's a lot of people on this call that have been surprised and shocked and afraid by this,
Mm-hmm.
that alone, from my perspective, is a huge mistake on the part of the attorney.
Mm.
In rare situations where I'm going to serve a subpoena, I almost always will pick up the phone, or my co counsel will pick up the phone and we'll talk about it first. It's rarely the case that we serve anybody with a subpoena, a therapist or anybody else, frankly, without there being prior notice.
Wow.
So
Okay.
I mean, that's just the overview. That doesn't necessarily give you practical things to
Oh,
do, but
well,
there's a little context there.
no, that's incredibly helpful. Okay, and just I'm like a pathologically curious person, Rich. So I just have to know.
I
So
love
then,
that.
what would motivate an attorney to start shotgunning subpoenas around instead of picking up the phone or maybe doing research, like talking to a therapist privately? Where would this even come from?
Yeah, great question. I don't have a great answer to that
Okay,
because,
like well, we
and this
don't
is the
know.
kind of thing that I'm perpetually curious
Mm-hmm.
about. Sometimes it's just sloppiness.
Uh huh.
Sometimes it's this sort of haphazard shotgun approach that we're just going to subpoena everybody under the sun and see what sticks.
Mm-hmm.
Sometimes litigators, and we family law attorneys are litigators by nature, they have an adversarial attitude and
Mm-hmm.
they don't stop and think about collaborative approaches, and that's
Got it.
unfortunate.
Yeah. Okay. This is so good to know, though, just because to tell you, I think a typical therapist, and certainly lots of different personalities, but tends to be highly conscientious, but also very like a worrier, a planner. Like they can go out into the future and catastrophize. And so what this happens, like when a therapist gets these letters, it mushrooms into this vision of them like being handcuffed and dragged out of court for having done
Yeah,
something wrong one way or another. But so I love what you're saying right now, which is actually you might not have to do anything at all. And
that's
dude over here maybe needs to slow the roll because you shouldn't have got that to begin with. Okay.
absolutely.
Okay. So, said letter is deposited on your desk and the passenger pigeon flies back out the window. What should happen? And if you're like a therapist looking at this letter, what do we do? Do we like
Okay.
immediately call Rich? What's the next step?
No, I appreciate that. So the first step, first of all, is, and I'm talking to a therapist who's much better at this than I am, but take a deep breath.
Okay.
Pause what you're doing. You don't have to, it's not on fire. Nobody gets subpoenaed to something that afternoon.
Mm-hmm.
Okay. Take some breaths, wait till you have some time to take a look at this. And the simplest thing after that is just to read it.
Mm-hmm.
You want to pay attention to a few different things on the face of the document.
Oh, okay.
Okay, so it's generally only one or two pages, often just the one page. Okay, at the top of the document will be identified the parties' names in the action. For
Mm-hmm.
my world, you have a petitioner and a respondent, typically in a dissolution of marriage case or a custody case.
Mm-hmm.
So you're going to see right away why you've been subpoenaed. Chances are very, very high that one of those two parties is your client.
Yeah.
Okay. So you'll see what it is. You give some thought to what your relationship is with that client.
Mm-hmm.
Are you involved in individual therapy or couples therapy? Okay. Just start thinking about this stuff. Then you're going to see the date and the time and the location that you're demanded to appear.
Mm-hmm.
My recommendation is before you do anything else, put that stuff in your calendar so you have a placeholder. Doesn't mean you have to go,
Okay.
but make sure you have that down. Okay. By the way, one of the first things, too, in terms of taking a breath is don't ignore it, obviously, right?
That's my
Take those
tendency. Like,
breaths.
just put it in a
Take
drawer
one
for
or
like
two
3 months.
minutes to, right,
Mm.
to compose yourself, look at it
Yeah.
that day. All right. I'm just saying, not maybe
Yeah.
that
Read
second.
the letter. Step one.
Read
Okay.
the letter. And you'd be surprised how often people don't.
Well,
Not that they
avoidance
know
is
the
a
world,
strategy. Yeah, maybe not an effective one, but
not an effective one. And we lawyers do it too. Doesn't make sense. Okay, so you see the information, you'll see the people involved, you see the place you're supposed to appear. Um, Oftentimes, it will describe what you are being testified, what you're being asked to testify
mm-hmm.
about. It'll give you some language about what the lawyer is seeking in terms of the subject of the testimony. Sometimes it will also demand documents. So
Mm.
you want to make sure you read all of that and just be aware of what you're being asked. Okay.
And the documents thing is a real big deal for therapists because case notes, so much private information can go into those. So, anyway, keep going.
Yep. So
Yeah.
thank you. So now you kind of have the lay of the land, if you
Mm-hmm.
will, what it is you're being asked to do and
Right.
when.
What do they
Okay.
want?
What do they want? Your next steps are sort of at your discretion here, but you need to figure out how you're going to deal with this and whether you're going to cooperate or not. Okay.
Mm-hmm.
I'd suggest a couple of different things. Number one, think about your own client. Your client will be identified on that document.
Mm-hmm.
Um, you probably should pull up at this point your engagement agreement, your
Mm-hmm.
contract with that client. Most therapists will have language in that engagement agreement, and if you don't, you should,
Mm.
about not agreeing to testify in
Yeah.
court, that there's privilege and there's confidentiality, and the client has agreed to that.
Mm-hmm. Yep.
So
And team, what Rich is saying is to have a section in your disclosure statement that says, by signing this agreement, you also understand that here's what I don't do, which is
exactly,
testify in court. Okay. Got it.
exactly,
Yeah.
and I can't imagine any therapist would not want to have
Mm-hmm.
that, right? It's to protect yourself and make it clear, right?
Mm-hmm.
So I would then consider, assuming you have that language, picking up the phone and calling the client and letting them know you've just been served with this.
Mm-hmm.
What you might find sometimes is the client didn't even know that the lawyer took that step,
Oh my
right? Have you
gosh.
seen that?
Yeah.
It's a
Completely.
it's a surprise. Under Colorado law, it is the client that holds the privilege. What that means is it is the client's right to protect his or her information. That individual needs to know that some lawyer, whether it's their lawyer or their spouse's lawyer or ex-spouse's lawyer, wants you to be forced to divulge information, confidential information about them. So
Mm.
that client should be aware of that. Sometimes that awareness will solve the problem. The client will call their lawyer and say, "What the heck?
Mm.
I didn't authorize this. Why do you want this?" They'll have
Right.
that conversation. It might go away.
Mm-hmm.
Okay. So the client has the privilege. If you have the contract, you also have a contractual legal right to resist
Mm.
because the client has given you that right to resist.
Mm-hmm.
Okay? So assuming one of those two things exist and the lawyer doesn't back down, that's when I think you need some legal advice in
Mm-hmm.
terms of resisting the subpoena the right way. Okay,
Okay. This is super helpful. So you're saying if it's your client and the client is like, no, I need to like get my lawyer to back off, or you have that passage in your disclosure statement that says, I don't do this, that is protective. Now, what about another situation where, for example, it's a custody case? Because this is like usually the scenario, right? It's a custody case. It was either your client or you were seeing a couple where you have obligations to two people. And so the ex husband's lawyer would very much like you to come in and he's on board, but that perhaps the other partner or the person who is your current or former client is like, no, and there are competing things happening. Where
Right.
what does that change anything in terms of?
It
Okay.
does.
Yeah.
And I get that's a common occurrence
Yeah.
or more frequent occurrence. So it does change things. So if you're in a couples therapy, typically it's all protected, but there are situations where you might be compelled to disclose information about the lawyer's client, not the lawyer who subpoenaed you, but let's say lawyer represents husband and the husband is serving you with the subpoena. Okay. If the husband is consenting to the release of his information, there are circumstances where the portions of your file relating to the husband and the information relating to the husband may be subject to being compelled.
Got it.
What I'd recommend, that's a sticky situation. I would do two things. I'd have a conversation with the lawyer who's asking for the information, find out what they want and why,
Right.
right? If they're persisting and you're not clear about what to do, that's when I think you need some
Yeah.
advice.
Yeah.
And if it's a stickier situation, because my gosh, you've got this legal obligation hanging over your head. You're a conscientious professional. You want to do the right thing. You have your own regulations that govern you and your own licensure. I think it makes sense to get some advice and tread a bit carefully in that situation.
Yeah, got it. Okay, because what you're saying is that if you have a current or former client who would like you to testify and their attorney is persistent about it, that even if you do have that section in your disclosure statement, you might still actually have to because it's at the will of that client that you're doing it.
Correct. Because
Okay,
that client is essentially withdrawing his consent.
right.
At that point, his not his consent, his right to have that confidentiality. He is the one who's now waiving that privilege and allowing you to testify about, in this case, him. The reason I want to emphasize talk to the lawyer if they're willing to have the conversation
Yeah.
anyway, is that you should be honest about, I mean, if you're in that situation and you confirmed that lawyer's client wants you to talk to the lawyer, and perhaps you confirm that with the client first,
Yeah,
right?
and I would imagine get an actual signed release from that client giving you permission for that specific purpose. Would that be an action step? Yeah, okay.
Really good idea, just to
Okay.
be clear.
Yeah.
Yep. Because the lawyer has an obligation to tell the truth and tell you that he's given the authorization, but I think you ought to protect yourself.
Yeah.
Yes.
Get your own. Okay. Good
Get your own,
advice.
right? So you have that permission. You call up the lawyer. Sometimes you can take the wind out of the lawyer's sails by suggesting somewhat gently that perhaps the information you have may
Ah.
not be as helpful to their cause as they think.
Oh my goodness. Psychological warfare, Rich. I love it. No, but seriously, to just suggest that it may actually be to your client's detriment to have me show up because I know things. And then they might back off a little.
Right, because
All
the
right.
things you know that you talk about, now the other lawyer gets a chance to inquire about these other things. One thing I've learned the hard way, more than once actually, is that my own clients, much as I'd
Yeah.
like to think otherwise, don't
Right.
always tell me the whole story.
They are self reporting in a positive light. They are the
Go
innocent
figure.
victims, Rich. And so to have somebody like me show up and be like, are you sure you want me to share all the details? I'm like, whoo, actually, maybe not. Okay.
Right,
Okay.
right, exactly,
All right. I love it. Self defense strategies for therapists. This is good. Yeah.
exactly.
Okay.
So you've had that conversation. let's say the lawyer who served you with the subpoena either won't take your call or is just being hostile and
Mm-hmm.
they want to proceed anyway.
Okay.
Okay. You do have the right to take action to either quash, which is kill it off, quash the subpoena,
Mm.
or to make a motion to modify that subpoena to make it far more limited in scope.
Mm-hmm.
Okay? Limitations could be helpful because you could get a judge to order on, okay, you have just these specific things and these specific things only that are kosher for you to talk about, not these other things. So now you have some protection. You
Mm-hmm.
might also want to suggest to the judge, and this is something I would always do, that look, I have a busy practice. If I'm going to get have to go to court and sit there for half a day until I'm called as a witness, that is really expensive. And number one, I deserve compensation for it because
Mm-hmm.
it's not automatic under the law.
Mm.
Number two, maybe I can be allowed to testify remotely like this on video,
Okay.
and that will save a lot of hassle and expense.
Right. That's a great idea. And so now, are you also saying, because I have seen clinicians do this, so even in that same section of their disclosure statement, where they're like, I don't testify, don't ask me to, they're also like, in the event that I do, it will cost you $900 an hour or something like crazy, just make it less attractive.
I
Is
think
that
that's a
what we're
good
talking
idea.
about right now? Okay.
Yes.
Mm-hmm.
So I'm glad you asked that, Dr. Lisa, because that's important. A lot of what you can do to help yourself are taking steps before you even get served.
Yeah.
Making sure you have the right language in the agreement, including compensation clearly
Mm-hmm.
spelled out. Absolutely.
Okay. Okay. And then to make modifications to the subpoena, that's where we would really need to partner with somebody like you who knows here's how to do it, here's what to say, the paper, the process. Like, the, yeah, okay, got it. All right.
Exactly,
Call.
exactly. And sometimes the
Mm-hmm.
best legal advice is, look, you can relax, you don't have to do anything, or you only need to take these limited
Mm-hmm.
steps. A good lawyer, and we can certainly help your folks with this. We can give you your options, and
Mm-hmm.
hopefully, filing the motion to quash is the last resort because it's expensive, and there are a lot of ways perhaps to avoid needing to
Yeah,
go that far,
got
if you
it.
will.
Okay.
Okay.
Well, just heightens everybody's anxiety. What are situations that you've seen therapists perhaps mismanage just because of not understanding all of the rules that have actually gotten them into trouble, either not showing up when they really did need to? And what does that look like? Or also, I think a clinician's biggest fear and that catastrophization piece is going and saying too much and they're in some breach of confidentiality or being grilled by an attorney like some drama TV courtroom style and they're like I can't remember, somebody's like you're lying, and they're in contempt of court for like false information and then hauled off to prison is how that typically ends in the fantasy. But what are the reality based things you have seen therapists actually get into trouble for?
Yeah, I love this question. Thank you. The first one you already you cited the most obvious one, and
Mm-hmm.
that is to just ignore it and not show up. Now, you might have every ground legally to not show up if you had filed the right motion,
Mm-hmm.
but just say, "Look, I have privilege. I don't have to go," is a mistake. Okay,
Mm-hmm.
you have been validly served with the subpoena, which basically means you're handed a document by somebody over the age of 18 who hands it to you or hands it to your office administrator, you're served. Okay. If you just ignore that, what will happen or what could happen is come the date of the hearing, the lawyer will stand up and say, look, I served the subpoena. Mr. Smith is not here. We need to have an order to what's called an order to show cause. The judge will issue this scary sounding order, and you'll be demanded to come back to court and explain why you didn't appear, You could be fined. You could be forced to pay attorney's fees for the lawyer who sent the subpoena. And sadly, that could be a big number. It could be more than $1,000
Mm,
just for
hmm.
ignoring it. And in a worst case scenario, if it happens more than once, and I want to alarm people, but people who avoid subpoenas can have a warrant issued for their arrest.
Hmm.
I've never seen that happen, but it's possible.
And I'm sure you know what is happening, Rich, related to this. You're aware of that scam targeting therapist. I've actually talked about this on other podcasts where, do you know what I'm talking about? There was like communications from door. Okay. So just very briefly for listeners who did not catch that scams targeting therapists episode, this is so sad, but bad actors will call a therapy practice or a therapist. And this has happened to me. It has happened in my practice numerous times. And this past year, Rich, a young clinician got hooked by this one, paid these people $500. It was so awful. So the phone call is, you missed a subpoena to testify in court. There is now a warrant out for your arrest. You are probably going to lose your license to practice therapy. And I'm sitting here at the police department. We're going to come get you. But if you pay this fine right now, preferably in cash or an Amazon gift card, I can make it go away. And that is a really prevalent situation. Yeah. So,
That's so terrible.
right.
And it never ceases to amaze me
Isn't it
the
crazy?
depths to which people will stoop.
I know.
And lawyers fall for these kinds of scams too,
Hmm.
different situations, but yeah, nobody demands money to make a subpoena go away. No judge would ever do that. Anybody who says that, I would get their name and phone number and ask them to mail you a copy of what they're talking about.
Yeah, totally. Oh, and it's not just therapists either. I am acquainted with a CPA who had that happen. And she was on the phone with these people for like 15 minutes. And she is a smart woman. And it sounded fairly convincing. But then she was like, all right, well, I guess come arrest me. I'm going to hang up and wait for the police to show up and get me and take me to jail. And they never did. Anyway, I don't want to get too far off track. But I also, I hear what you're saying, that if you are actually getting sideways with a court of law, there are going to be different actions before you're getting arrested. So there's going to be you'll have to come and explain yourself, and there will be efforts to contact you. And also,
Yes.
just out of curiosity, in this day and age, is it like just a letter? Because I know a lot of people highly avoidant around mail. But are there like emails, phone calls? Is there more than one channel, or are you receiving a piece of paper with your name on it?
Good question. Look, first of all, I've been in practice for more than 30 years. I have
Hmm.
never, ever seen a therapist jailed for avoiding a subpoena. Never, ever. In my experience, the judge is going to want to hear that the lawyer went through extraordinary efforts to contact the person
Hmm.
and find out what's going on. The official way is the letter, yes. So you should
Okay.
open your mail. But I'd be shocked if you didn't also receive emails, phone calls, probably multiple attempts.
Yeah. And like with the subpoena, people are literally showing up to your house or your office. Yeah, you would know. Okay.
You would know.
Okay.
Absolutely. So back to the good question you asked, Dr. Lisa, what other mistakes might you make,
Yeah,
right?
definitely.
The other big fear that you identified, and I think it's legitimate to be thinking about this. If you end up going to court and you're testifying, what I strongly suggest is a couple things, and I would tell this to any witness, my own clients when I'm coaching them on how to testify. Make sure that if you're in one of these TV Cary Grant moments where the lawyer is screaming at you and you can't think straight,
Ugh,
first of all, almost no judges permit that. Okay.
good.
So it's really rare, but it could happen. Ask to take a break.
Okay.
Ask to take a break. I've never in my career
Hmm.
seen a judge refuse that.
Okay.
You can have a glass of water, you can even take a few minutes, you take a
A
break.
Xanax. Oh my God. Can you? Not really. Just
But
kidding.
you take a break. You want to make sure that you're careful about what you say.
Yeah.
And then what I would suggest is there's not a specific perfect answer to the questions you're being asked. One
Mm-hmm.
of the best answers in the world and the most truthful is, I don't know. I don't remember.
Mm-hmm.
May I look at my notes? I'm not sure. Okay. Make sure you're aware of the question being asked before you answer it. And if you're feeling befuddled or confused or stressed, because it's a stressful situation, ask to take a break.
Mm-hmm. Yeah.
Okay. Most judges that I appear in front of are very kind and they're very protective because they get what's going on. This is a fight between a spouse and another spouse.
Mm-hmm.
Um, the professional is almost always trying to do his or her job,
Mm-hmm.
and judges will almost always protect that and honor that.
That's good to know because that's scary. And I think just as a therapist who doesn't have a great memory, by the way, I would worry about my ability to remember some of the facts and details. And this also might be, say, a couple that you haven't seen in 2 or 3 years. And additionally, I don't know if you know this, but, and I say this as a clinical supervisor, therapists are trained to put enough into notes so that you are documenting what's happening and can go and refresh your memory, but you actually don't want to be overly detailed in notes in the event that you do have to hand some of these things over. So we're finding a middle path between enough information, but not too much. But again, really then 3 years later, having to look at these notes and then be asked specific questions about what happened or didn't happen. I mean, it's a thought of that is very stressful, and being worried about either factually accurate information, but what you're saying is that it's okay to say, I don't remember, or perhaps even that is a level of specificity that would not have been in my case notes. And I don't recollect what we talked about in April of 2017, that kind of thing.
Exactly.
Mm-hmm.
I mean,
Okay.
you're a human being, you're a professional. By the
Yeah.
way, what you're saying to me, Dr. Lisa, is helpful for me to know. That makes sense to me that you wouldn't include
Yeah.
all those details in your
No.
clinical notes.
Mm-mm.
It makes perfect sense, and I think that's wise. And the reality is, if you don't remember,
Mm-hmm.
and or it's not there, it is what it is.
Right.
Just be honest.
Okay, well, that is great to know. And then, okay, so related to that, I think another thing that really stresses therapists out is that would there be questions that would go into our, like, almost opinions? Or so, for example, like when writing psychological reports or evaluations, we need to be really careful that we are not making sweeping statements about who somebody is or predicting future behavior, right?
Mhm.
Because we don't actually know. And have you seen instances where therapists are being asked questions about character or predicting future behavior or things of that nature that therapists really cannot say? Because it's also true that whatever people were telling us in therapy sessions is self reported information that we may or may not actually know how they show up IRL in real life, as the kids say, right? It's just the information that we're provided, but then we're being asked to provide testimony. Like that is incredibly anxiety provoking. What is your sense of what happens with that?
Yeah, that's a great question. So I do see that, and lawyers will
Mm-hmm.
push and push,
Mm.
try and get you to stretch and provide analysis or opinions about this kind
Yeah.
of stuff. You can't do so. You can't provide. I would, in that situation, first of all, hopefully you've had the conversation with the lawyer and you've explained, look, if you're going to ask me whether this person is going to continue to use drugs or continue to neglect their child or that kind of thing, I'm
Mm-hmm.
going to say I don't know because I don't. Number one, I'm having self reported information. Number two, I can't predict the future.
Yeah.
Number three, you might say, I've seen this person in this limited setting. I don't have a diagnosis. Sometimes maybe they're asking you to give a diagnosis. Well, isn't it true that this person is bipolar or this person has this personality disorder?
Mm-hmm.
The answer might be yes, but the answer might be either no or I'm not sure. I have not provided that diagnosis, and that's not my job in this situation.
Okay. So what you're saying is that get clear about what you can and can't say, what your limits are, and don't be afraid to push back.
Exactly.
Yeah.
Yeah,
Okay.
that's a
That's good
really good way to
advice.
put it. Push back with the lawyer.
Yeah.
You're a professional too, and you have legal obligations too. Let me just give you the statutory site so that your audience
Oh,
can
yeah.
have.
And you guys will include the links to these resources that Rich will share in the article that we'll put together in support of
Yeah.
this podcast so that you'll have
Okay,
those.
great.
But there are specific statutes and rules.
Exactly. The most important one is a Colorado statute with these numbers: 13-90-107.
Okay.
Nobody should remember that or memorize it. I don't. I'll look it up every single time.
Yeah.
That is the main statute that protects you and your privilege and your confidentiality.
Okay.
Right? So don't. I bring that up because when you cite back to the lawyer the law, sometimes you're gonna make some hay. That lawyer's gonna realize, okay, this person's not a pushover.
Okay. All right. And also we have friends and colleagues listening all over the place. And so there's probably a statute like that in whatever state you're living in. But I think I'm also hearing within that, Rich, that if you get this far into the situation, you should probably have an attorney in your corner being there to support you and advise you and help you figure out what the statutes are, what your rights are in this situation. And then on that note, just out of curiosity, so through no fault of your own, now you're in the washing machine with the rest of these people, this legal scenario that requires you to be probably also paying for an attorney. Do therapists have the right to be billing for these attorneys' fees that they are now having to pay somebody else just because now they need to participate? Is that billable?
That's a really good question. I suggest you make the answer to that yes in your
Okay.
agreement. You
Oh,
decide by contract. Okay, so
okay.
when you say, look, I'm not going to testify if I'm subpoenaed. If I'm forced to testify, you're going to pay, and my hourly rate is X, and my travel time is an automatic 2 hours, you're going to pay for that too. In addition to that, if I'm required to consult with counsel, you agree to reimburse me for all of my legal expenses.
Oh my gosh, Rich, that is not in my disclosure statement. And that is going to be in my disclosure statement as of
Good,
this week. Thank you.
good. And I can't say with 100% certainty that it's enforceable, but it's certainly not an option
Yeah,
if it's not there, A.
right.
And B, I think it will be enforceable because you're creating a contract. That client doesn't need to sign you on as his or her therapist if
Right.
they don't like it. But if they agree to it, and by the way, have them initial next to that provision, I think you're going to have luck with that.
Yeah. That is phenomenal advice. Rich, this is so helpful. And I feel like we could just talk all day about this because it's such an important topic. Obviously, you are such a wealth of information, but I feel like we've covered a lot of really good do's and don'ts. Are there any other like pro tips you would like to drop that we haven't talked about yet that therapists should either do or absolutely not do in order to manage this well?
You bet. First of all, thank you, Dr. Lisa, and I always enjoy these conversations.
We have a good time, don't we? Yes.
We do for sure. I just offer a couple of final thoughts here. Number one, we haven't talked about it, but I assume it goes without saying. You guys all know this, but a huge exception to the confidentiality rules is if you have reason to believe that a child has been abused.
Oh, yeah.
Obviously, you're a
Absolutely.
mandatory reporter that everything we're talking about goes away. If you get that information, do what you need to do, which is contact law enforcement. If you're subpoenaed to talk about that stuff, you probably will have to, and you probably should.
And we'll want to,
And you'll
by
want
the
to,
way.
thank you, right?
Yeah, give me a chance.
Yeah, for sure. The other thing is The other big category of subpoenas we haven't talked about is there are folks in your profession, and we work with them all the time, who do child custody
Mm-hmm.
evaluations, who
Mm-hmm.
act in a role specifically designed to provide courts with information. That's a whole separate subject.
Mm-hmm.
Sometimes you have a right to affirmatively testify in that
Mm-hmm.
situation. The rules are totally different. If you're in that situation, make sure you're very intentional about what you're agreeing to do and what you're not in the engagement agreement.
Okay, got it. And so now we're talking about like child and family investigations, custody
Exactly.
evaluations. I, just for our listeners, did record a podcast on this topic a few months ago about things for therapists to know. But this is a great reminder because you're saying being subpoenaed is different from that, and that a therapist should also have real specific language in their agreement about that,
Right.
participating in an investigation, because that's another thing that can commonly happen.
Well, I'm not sure that you have to have it in your
Oh,
general client
okay.
agreement, but it should be in your order for appointment, your engagement on specific cases, that
I
you know
see.
exactly what you're
Hmm.
agreeing to, what you're not.
Got it.
As an aside, quick pitch, um, we don't have nearly enough of these people.
I
Really
know.
talented, ethical people who are willing to do CFI work or PRE work, which is parental responsibilities evaluations work.
Hmm.
We need more, and for what it's worth, it pays well and it's very much in demand.
Hmm.
So I could talk about that for another 2 hours, but I'm not going to. But that's a
Yeah.
field where we need more good people.
Absolutely. And I'll just share. Do you know, I don't know if you know Stephanie Randall. She's another Colorado attorney and
Yeah.
she does a lot of CFIs, and she and I are acquainted. And she came on the podcast a few months ago and it was so eye opening for me, Rich, and I think for the rest of our therapists community, because she was talking about this problem where unfortunately there aren't enough child and family investigators, or sometimes they aren't very well trained, or they have significant biases that can color the ultimate outcome of their reports in ways that can be really damaging sometimes to families, particularly when there are domestic violence situations, honestly. So she
Yeah.
dropped a lot of information, which was helpful. But you bring up a good point that just like we need more people in those roles as a profession. And so if somebody did want to pursue that as a potential either career path or even something that they did in addition to their primary job, where would you start to get the training and get on the trajectory to become a CFI?
Yeah, great question. From a practical standpoint, what I would
Mm-hmm.
do is I would call Stephanie or somebody else who already does this.
Mm-hmm.
And
Or
just
Rich
ask.
at Harris Law. Okay.
I'm happy
Yeah.
to help too. The reality is that nobody should feel threatened by those questions,
Mm-hmm.
because every single good CFI out there, the good ones, is in incredible demand.
Yeah.
Most of my conversations with these folks are not, how much do you charge? It's, can you please help or not?
Right. Right.
And most of the time they can't because they're overwhelmed
Of
with
course.
work.
Mm. Now, do therapists ever branch out into becoming CFIs?
Yes, they
Okay.
do.
That's awesome. Because on this show, we talk about a number of different things related to the life and times of being a therapist. But I think that a lot of we keep circling back to over and over again is around a diverse professional experience for therapists, many of whom want some diversity in their professional roles, to have one on one sessions with clients, but also to do things like CFIs, PREs could be another way of expanding your practice and your skill set. So I'm really glad that you're bringing this up today, Rich. That's great. Yeah.
Yeah, I really do encourage it. And
Hmm.
I like the idea of a diverse practice. And what I'd
Yeah.
also offer is these individuals can accomplish tremendous good, particularly on the behalf of children.
Hmm.
Um, Judges really listen to these kinds of reports
Mm.
and they carry a lot of weight. And
Yeah.
so for folks who want to do something different and really want to make a difference specifically for kids, it's a great thing to do, in my opinion.
That's awesome. Thank you. Thank you for bringing this up. Okay. Rich, did we cover everything? You started sharing some tips. We had a very important little side conversation there about CFIs, which was incredibly valuable. Any other tips to drop about being subpoenaed, or do you think we've done what we came here to do today? Perhaps there are different or additional questions to get directly in touch with you could be an option, but any other last tips or words of advice?
Well, as usual, Dr. Lisi, you've asked the most amazing questions. I think we've pretty much covered it. It's a
Okay.
complex subject.
It is.
If we can be of assistance to your listeners, we're happy to.
Mm-hmm.
Again, I view good colleagues out there in your profession as kindred spirits, and if we can help,
Yeah.
we're delighted to.
Well, that's amazing. And I think all competent, effective therapists know that we cannot do this alone, and we need to be partnering with other professionals like attorneys in order to be able to manage these realities. And so tell people where they can get in touch with you if they wanted to talk with you personally, or perhaps attend one of your amazing webinars that you do on the
Thank
reg.
you. Okay. So a couple things. We do webinars almost every Wednesday night from
Mm-hmm.
5 to 6 p.m. Mountain Time. They're available for free. You can also download recordings of those at any time. It's on our website. Our website is harrisfamilylaw.com. That's an easy way to get in touch with us. You can always give us a call too. They'll get you in touch with me.
Thank you again so much for doing this with me today, Rich. And of course, we'll link to all of the different resources that you shared. But thank you again just so much for providing such detailed, actionable information about do's and don'ts for therapists, because I feel like everybody listening to this just has a lot more clarity that I hope will help not just manage the anxiety, but inform next steps. Oh, I know what to do. So thank you.
I'm so glad. Thank you for the opportunity. I enjoyed it.